students. Welcome to this new session of the Signature of Public International Law. We are in the session number 27 in the unit 13, Peaceful Means of Resolving International Conflicts. Today we are going to see the subunit 13.1, Diplomatic Means, and 13.2, Legal Means. The objective of this session is to analyze diplomatic and legal means and their impact on international law. Remember that when we finish this session, you will have to perform an activity about the student exhibition where you will present a short video with some success story of diplomatic media in the resolution of disputes. Don't forget to watch the add-on videos and to read the PDFs as well as you use the Genially to study for your exams. So, starting with the topic of today, types of disputes at the international level. We have two types, political disputes and legal disputes. The political disputes are those that cannot be settled by legal means, and the legal disputes are those that can be resolved only by legal settlements procedures. Origins of the term peaceful settlements of international disputes. It is origin of the Convention of the Pacific Settlements of International Disputes at the Hague Conference in 1899. Also, what are they? They are the procedures of settling disputes between states either in terms of law or on other principles. These methods are relatively modern as they can only occur in a more or less integrated international community. Which are the types of means of dispute resolution that we have? The politicians or the political means and the legal. The type of political means of dispute resolution or non-judicial means of settlement are the negotiation, the good offices, the mediation, the commission of inquiry, and the conciliation. The negotiation is the direct settlement from state to state by common diplomatic channels of the conflicts that arise between them. Are two states that try to negotiate between them. The background is that before submitting a dispute to a Security Council, an attempt shall be made to settle the dispute first by negotiation, as we can see in the Article 33 of the Charter of the United Nations. It is the oldest means of dispute resolution methods and the one that handles the largest number of cases. You can all go along or you can be equally accompanied in other type of arrangements. The good offices, it occurs when a country urges to contending nations to resort to negotiation among themselves. They are spontaneous. The mediation, it occurs or happens when a country conducts negotiation between two contending countries. It varies from an international pact that grants the authority of the state mediator to intervene in this way. It is provided by the Article 34 and 35 of the Charter of the United Nations and the Charter of the Organization of American States. The Commission of Inquiry. They are established by the Hague Conference in 1899 as a formal institution to clarify the facts that lead to the controversy. The report he or she submit as a result of his work is non-binding and only serve to shed light on the dispute. What is the conciliation? The conciliation is a process instituted by the same parties where they not only investigate the facts conducive to dispute but suggest some viable solution. The opinion of the Conciliation Commission is binding on the parties. Its origin is located in the Bryan unfurling of theaters which were seen in 1914 between United States and several Latin American countries, so as not to resort to hostile means until the report of council of Conciliation Commission had been made public. It was given much importance in the Treaty of Pacific Solutions of Pacts of Bogota in 1948. We have also type of legal means, which can be the judicial decision or the arbitration. The arbitration is a method in which the parties to dispute agree to submit their differences to a third party or to a tribunal especially constituted by this purpose, with the objective that can resolve according to the rules of international law the parties may specify. Usually, in terms of international law, they have to make this resolution, and with the understanding that the decision must be accepted by the disputed parties as the final of the settlement. Also, we are going to analyze the differences between arbitration and mediation, the appointment of arbitrators, the composition of the permanent court of arbitration, the composition of the arbitration tribunal, the difference between arbitration and international jurisdiction, and has maximum development been achieved in this settlement of international disputes. There are more 200 of bilateral and multilateral instruments for the settlement of disputes. The fact that there are so many is already an indicator that the settlement of disputes at the international level has not really been overcome.